statute. Section 23 of the UGC Act, which is noted by Aziz Bhasha, says it must be by statute. At the same time, it takes the view that if you are statutorily established, then you are established by the statute and not your antecedent history. The second, my lord, is Aziz Bhasha, my lord, recognizes the background and antecedent role that the MAO College made in building this institution. This it does at page 849. I'll show to your lordships. And it is said, my lord, it is clearly Muslim. The third point that I want to raise before your lordships, because I want to take your lordships to the Act of 1920 and of course the Act of 81. It ignores completely the purposes of the Act. So all the provisions that actually deal with its Muslim character are totally and completely ignored. Now, my lord, there is one thing, and your lordships will appreciate that. Aziz Bhasha, my lord, does not wholly understand how universities are run. It mentions the Governor General, it mentions the Rector. Universities, my lord, have a dual system. Firstly, and your lordships will appreciate this as Chancellor, and this is that you will supervise if necessary, you will inquire. All that is written, my lord, for example, in section 7 of the Bangalore. It is there in NUJS, it is there in Sanction. So one aspect, my lord, is the external institutions that are kind of suo motu ombudsman. The second part is the statute itself and the institutions of the minority. The emphasis in Aziz Bhasha that the rector has this enormous power, my lord, is unfounded. In all universities, the rector later became the visitor. In all universities, the chancellor, the rector, or the visitor has this supervisory power, and that will not, my lord, interfere at all with the minority status. My next point is, my lord, that Aziz Bhasha ignores the alternative meanings to establish. This is relevant for our understanding of Mother Provincial. It also understands but misunderstands the importance of recognition. It says recognition, why is that? That takes everything away and you become really nothing more than an institution of government. These are the broad arguments, my lord. Because Aziz Bhasha takes a very narrow view of Article 30. Now, my lord, may I take your lordship to Aziz Bhasha? It's volume 3, lord. 3A. Will your lordship turn to 3A? We feel, my lord, it was so much better to hand over the books.
So much better this way.
I know, my lord.
There's no time spent in handing over books.
No, but the point is, one went straight to the point, and then the books came out, went into the. So there was a continuity that we had, which is somewhat broken, my lord. But that doesn't matter, my lord. I told your lordships I'm a Luddite and I'm amazed at your lordships' dexterity. Now, my lord, page 3 of 3A is where the head note is. From the head note itself, which I won't read out, but I'll read from the judgment. It goes into the antecedent history and says it's very important, and then ignores it because the 1920 Act is there. But let me take your lordships, my lord, to the judgment itself. Now, my lord, page 7. The Union of India's stance, my lord, was that it's not a minority institution, but also it defended the statutes of 1951 and 65, which were before the court. Now, my lord, there have been further developments. We have the 1981 Act. How can you now say the 1981 Act? I mean, I can understand that the Allahabad High Court knocked down 3 provisions of the AMU Act because they said it was a usurpation of the judicial power. Now, my lord, the Chief Justice has dealt with this and Pavitra too. I won't go into greater detail about it. No? Did the 81 Act change the basis, or was it a usurpation of judicial power? In knocking down the preamble in 2 sections, which I'll show to your lordships, in actual fact, they said it's a usurpation of judicial power and it's non-est. Now, my lord, kindly come to page 8. Here is the history of the establishment, and it says it's necessary to understand it. I'll give your lordships a fuller account. I won't take your lordships through it. Now, 1870, Syed Ahmad Khan says the Muslim community is neglected. Then, Lord, there's a whole list of negotiations, which I'll show to your lordships. He wanted liberal education to Muslims. Then he says in 1872, the MAO was established. And then, my lord, in sequence of activities, a school was opened. Then Lord Lytton laid the foundation stone. The MAO College was established thereafter, and it is a flourishing institution by the time of Syed Ahmad Khan. Then, my lord, at the bottom of that page, and your lordship has to see that, long negotiations took place. That's the last 3 lines on that page. Between the association and the government of India, which eventually resulted in the establishment of the early government. Now, that is the antecedent history. We have to review it in the light of my Lord St. Stephen's. The antecedent history is important because your lordships will see that even St. Stephen's was, in fact, a constituent college under a statute. All our deemed universities are actually, as Mr. Dwivedi pointed out to the court and Yashpal, are and under a statute. If Aziz Pasha is taken at its limits, it could destroy the entire system. Now, my lords, it is mentioned that before a large sum of money was collected by the university, as the government of India made it a condition that rupees 30 lakhs must be collected for the university before it could be established. Further, it seems that the existing MAO college was made the basis of the 1920 Act for the administration of the university, along with the properties and funds attached to the college, the major part of which was contributed by Muslims. This is the antecedent history, and Justice Vancho recognizes this. But he says, I'm sorry, the 1920 Act, they'll go by the establishment, and that's the end of it. Then, my lord, the preamble says it is expedient to establish and incorporate a teaching and residential Muslim university and to dissolve the societies under the Society Registration Act, which are known as MAO. Aligarh and Muslim University transferred to vest in the university all the properties and rights of the said societies and the Muslim Universities Foundation. Now, this is important, my lord, because a continuity was established between the pre-1920 Act and the 1920 Act. This continuity is fundamental to our understanding. Justice Vancho realizes this, but then ignores it. Now, my lord, kindly come to section 3. It also mentions, my lord, opposite place H, that section 4 dissolved the MAO College and Muslim University Association and all the property, movable, immovable, and all rights and powers of the privilege were, my lord, were transferred to illegal. This is the continuity in section 4. How can you ignore it? MAO is now being transformed by section 4. Of course, my lord, earlier, because of section 23 of the Act, the court, which was the big body, had almost absorbed it. That was amended in 1951. Now, my lord, over the page. Now, my lord, kindly come to place C. These provisions will show that the 3 previous bodies legally came to an end and everything that they possessed of was vested in the university by the 1920 Act. Of course it was, but the continuity, and nowhere you will see in the Act, as I'll show to your lordships, the Muslim character. Section 6 is important because Justice Manchu finds fault with the fact that the degrees, etc., will be recognized by the government. This is precisely what your lordships have said in Kerala Education and others. Recognition must be given. Then, my lord, your lordships will see 13. 13, my lord, as I pointed out, is a misunderstanding of university education. Because university education, my lord, is based on 2 templates. The external template, which is chancellors, visitors, visiting board. And then it is provided that the Governor General should be the Lord Rector. This becomes visitor later on. And then it mentions at the bottom of the page that the Lord Rector shall give notice to the university of its intention to cause an inquiry.
You said university education is based on 2 templates. One was the external.
And the internal.
And the internal would be the internal management of the university? How would you define
it? Be, my lord, how the university runs. This template is important. And I might mention, since your lordship, Lord, is a chancellor of these universities, look at section 7 of the Bangalore Act and the Calcutta Act. They're similar. Then, my lord, your lordships will see section 14, which is now no longer there. But the important point, my lord, is at E. I'm sorry, my lord, my learned friends want me to read C. The provisions clearly bring out the final control. It's not a final control. In the template, it is a supervisory control. May I sit down for 2 minutes more?
I'm sitting down.
You, Mr. Dr. Dhawan, there's no difficulty. You don't have to stand and argue.
I noticed that Mr. Parasar and your lordship said he could sit down.
I know, I remember that.
And he said no. So I must resist, my lord, and suffer this up to lunch.
You can sit down, doesn't matter.
Dr. Dhawan, this is because of your lower back issue. Please sit down and please sit and argue.
Yeah.
That's perfectly fine.
Aggravate, it might aggravate.
Yes, kinds argued.
Out of concern, I'm saying.
And you can move the podium aside. You can move the podium aside and you can have a seat and
Mr. Parasaran didn't have the back problem. You
you
can.
can come on the side and
Thank you.
in fact, if you have a special chair in your office, I didn't know that this is a issue with your back. You could have brought the chair here and sat on the chair and argued. It's so much more comfortable.
No, that's very kind of you. One must suffer, my lord, the traditions of this court. May I just sit down and place this, my lord?
Yes.
Requires a lot of courage. I feel very unwell anyway.
Anyway, my lord, those things should not be told to the court. Now, my lords, kindly come to section 23(2). The Supreme Court, the supreme governing body, would exercise all the powers provided by the 1920 Act. That's page 12, Placetum C. This is the distinction between external and internal. It's a misunderstanding of how universities are run. Sir Ashutosh was Chancellor, my lord, of Calcutta, and he took a very prominent view, my lord, in developing Calcutta institutions, Calcutta University. Now, my lords, I come to section 23, my lord, your lordships will say, see that in the 1920 Act, only Muslims, my lord, were members of the court. The court is the supreme body. Now, my lord, I've already dealt with section 24-25. What is said, my lord, between place F and G is a little sentence. This provision clearly shows that the final power rested with the Governor General. Now, my lord, that's the Chancellor. And of course, his role completely went, my lord, because he appointed only the first Vice Chancellors, etc. But somebody had to do it. Now, my lord, the whole import of this is at the page 13 at the bottom. If anything, some of the important provisions to which we have already referred shows that the final power in almost every matter of importance was in the Lord Rector and the Governor General in Council. Now, my lord, this is misunderstanding the template. The Rector disappeared, my lord, and became the visitor. Do visitors have that kind of right to supervise? Very importantly so, my lord. Then, my lord, if your lordships will come to place C, my lord. So, my lord, the internal part is mentioned in 14, but I come to place C. The annexure to the 1920 Act gave the names of foundation members of the court, numbering 120 who were all Muslims and who were to hold office for 5 years. Then section 9 was deleted, my lord. Now come, my lord, to page 15. The next substantial change was made with the proviso of 23(1). This is done in 1951, my lord, where while the court becomes the supreme body, it need not be all Muslims. Now, my lord, there is a decision of this court in Gandhi Faiz-e-Azam. Krishna Iyer, my lord, with a dissent, that the fact that you place other people on your board doesn't mean that you lose your minority character. Just as Justice Das says sprinkling of in DMFI. I'll show those, my lord, judgments as far as required. Then, my lord, if your lordships will come, at 16, place F. I must say, I'm more relaxed, my lord. I'm very grateful for your lordships. Sorry, my lord. I apologize. Now, my lords, kindly come to F. We shall proceed, that's the third line, just opposite L, on the assumption that the present petitions that Muslims are a minority based on religion. Had he looked at the entire act, my lord, he would have realized what the purpose of the act. Now, my lord, if your lordships will come over the page, we come so, my lord, there is really no dispute that they are a minority. And Aziz Bhasha says so in so many words. We accept that it's a minority. We accept the connection with MAO. MAO, my lord, was just the AMU was just the alter ego, my lord. It is a continuity of the MAO Act. Now, my lord, kindly come to page 18.
Page 16 and 17, they say that words establish and administer must be read conjunctively.
I'm coming to that. Of course, my lord. But as I said, these are the rights that flow from Article 30. The indicia of what is a minority, numerically, historical circumstances, the nexus which St. Stephen's and others see, that is the important aspect of which goes to recognizing a minority institution. Established and administer are the rights that follow. So now, my lord, 17, your lordships will see at A. The words establish and administer must be read conjunctively. It reads to give the minority to administer an institution provided as it has been established by, provided it has been established by it. So the more important point is establishment, and the right to administer will flow from it. That's important, my lord, because Justice Vancho recognizes, but where does where does it get knocked out? On the first stage. You were established by statute. So he says, where is your right to administer? It's not there at all. Then, my lord, there is, now this, my lord, is all conjunctive and this, I won't go into that. Now, my lord, the three questions on the top of 18 in Aziz Bhasha was whether it was established by the minority, first question, whether the right to administer ever vested in the minority, and even if the right to administer properties came to be the university, the minority before the establishment of Aligarh University, whether it had surrendered, it has been surrendered when the Aligarh University came to be established. Now, my lord, there's a very interesting, at C, just top of C, that paragraph. Before we do so, we would like to say educational institutions are of a very wide import and would include university. Now, my lord, this is a contradiction. On the one hand, you say if it's established by statute, then you have not established it. And this is of far-reaching consequences. And then the UGC Act, my lord, specifically says You must do it by statute and by no other method. And then, my lord, this was not disputed on behalf of the Union of India, and therefore it establishes, it may be accepted that a religious minority